Ready? Start. That the appeal filed by the appellant is against the judgment and orders dated 21/9/2019 of the Principal Judge Family Court, Patiala House, New Delhi, whereby the application filed by the respondent for transposing her as petitioner in the petition filed by the appellant, declaring him as guardian of person of baby Raina and appointing him as her guardian, came to be allowed on the finding that the appellant had abandoned the petition on the same day by a separate order, the respondent was appointed as sole, exclusive and absolute guardian and custodian of minor child, para. Both the parties have resorted to multiple proceedings against each other, essentially emanating from the discordant material relationship between them, Besides the guardianship petition filed by the appellant, the respondent had filed habeas corpus petition on 2 occasions, and because of non-compliance of the directions issued by the court regarding custody and visitation rights, both had to file contempt petition against each other, para. The appellant as well as his parents have also filed a special leave petition against the judgment of the High Court in habeas corpus petition and contempt petition, para. As aforesaid, during the hearing of the said proceedings, parties consented to the transfer of first appeal pending before the High Court against the orders of the Family Court, dated 21/9/2019, which essentially involves issue regarding guardianship, Besides, a divorce petition is also pending between the parties, para. B. That as it may, when the cases between the parties in this court were listed for analogous hearing, it was deemed appropriate to first deal with the question of guardianship, to which suggestion the parties favorably responded and have addressed the court on the aspect of that matter, para. Intriguingly, despite this court-wide order dated 29/7/2020 had withdrawn the stated first appeal pending before the High Court and transferred it to this court, the High Court, on 6/8/2020 in the very appeal, even after taking note of the order dated 29/7/2020 passed by the court, proceeded to dispose of the appeal along with pending applications therein, para. That obviously could not have been done by the High Court, for it had ceased to have jurisdiction to deal with the appeal any further after the order of this court dated 29/7/2020, Nevertheless, both parties advisedly argued the transferred case on merits without reference to the order of the High Court dated 6/8/2020, para. As aforesaid, there are multiple proceedings pending between the parties, but in this judgment, we may confine to the basic facts for answering the matter in issue before the regarding guardianship, para. At the outset, we may note that for the nature of order that we propose to pass in the present transferred case, it may not be necessary for us to advert to all the factual matters pointed out by both sides, para. The appeal is partly allowed in the aforementioned term referred to in paragraph 42 to 44, The transferred case is accordingly disposed of, full stop. No order as to costs, full stop. All pending applications in this case are disposed of.